Hi, my name is Shilpa Mehta, and I'm a lawyer with the Feldstein Family Law Group. Today I will be discussing with you the issue of more than one matrimonial home. Specifically, I will discuss whether a seasonal residence, which was owned by one party prior to the date of marriage, qualifies as a matrimonial home under the Family Law Act. The Family Law Act deals with a variety of issues that may become outstanding upon the dissolution of a relationship. One subtopic that the Act deals with is property division for married couples. The general idea of this legislation is to ensure that both parties equally share in the growth of assets made by both spouses or partners during the time they were together. Assets owned by married people prior to the date of marriage are not included in the computation of that party's net worth. The legislation takes into consideration that the other spouse or partner did not contribute to the attainment of these assets. However, the value of the matrimonial home, whether or not it was owned prior to the date of marriage by either party, cannot be deducted from the computation of the owner's net family property. The matrimonial home has its own special place in the legislation and is treated differently than other property. In light of the special treatment afforded to the matrimonial home, it's even more important to understand what factors impact whether a seasonal property, such as a cottage by the lake or a condo by the sea, will be treated as a matrimonial home at the end of a relationship. I've recently had to deal with this issue on one of my client files, and will explain to you what factors are taken into consideration when determining if that property constitutes a matrimonial home under the Family Law Act. Under Section 18, subsection 1 of the Act, every property in which a person has an interest at the time of separation and the property was ordinarily occupied by the person or his spouse as their family residence is considered their matrimonial home. The wording of the Act anticipates that spouses may have more than one matrimonial home by stating that every property in which a person has an interest may be a matrimonial home. This property also needs to be ordinarily occupied by the person and/or his spouse at the date of separation. The reference to ordinarily occupied only makes sense if you read it together with the next part of the definition, that is, as their family residence. According to this definition, there is no condition that requires spouses to occupy the matrimonial home together or concurrently. It simply provides that both spouses must be occupying the home as a family residence at the date of separation. Arguably, if a family is using their cottage on weekends during the summer, there's a propensity to characterize the property as a matrimonial home. It is important to note that Section 18.1 of the Family Law Act does not mention that the asset or the home must be routinely used for family purposes or as an accommodation. In light of this, a couple may actually have more than one matrimonial home. Again, if a couple also has a summer home and they have lived in that home during parts of the summer vacation, this home could then be considered a second matrimonial home. The law with respect to the division of the matrimonial home would apply to the second matrimonial home as well. If you'd like more information about this or other family law topics, please visit our website at www.separation.ca. If you'd like to schedule a consultation to speak with one of our lawyers about your family law matter, please call us at 905-415-1636. Thanks for watching.